Hello, everyone, and welcome to today's webinar presentation, Avoiding Common Pitfalls of Workplace Investigations. Workplace investigations are highly important in today's litigious workplace, but they can be tricky to execute properly. In this presentation, Noah Garber will help you understand not only how to conduct an investigation, but how you can avoid common pitfalls. Before getting further into today's topic, I would like to take a moment to introduce myself and my organization. My name is Zielinski, and I am the Marketing Director of ComplianceHR. You may recognize my name from the email invitations that you received for today's event, but to prevent a few popular questions from entering our Q&A box, I would like to let everyone know you will receive a recording of this presentation, and it will be emailed to you from ComplianceHR webinars, so please keep an eye on your inbox. Now, a bit about ComplianceHR for anyone who may be unfamiliar. ComplianceHR is a joint venture between two incredible and innovative organizations, the AI technology company Neota and the law firm Littler. ComplianceHR delivers expert employment law guidance in a fraction of the time of traditional methods. Our goal is to simplify the complexity of employment law, something we will learn a lot about during today's presentation. To achieve that goal, ComplianceHR offers a suite of technology solutions around critical HR compliance topics like employee overtime, independent contractor classifications, employee handbooks, and so much more. Today, I would like to introduce you to our two most used and most popular solutions, PolicySmart and the Reference Center. PolicySmart is a comprehensive handbook solution that provides you with federal and state compliant templates, a compliance policy timeline handbook, checklists, and even automated emails to alert you on new legal changes going into effect. The Reference Center is a solution that combines many of our rapid reference tools to provide you with instant information sourced from Littler's incredible database that provides deep insights and bridges multiple compliance concerns. With reporting that compares jurisdictions and topics, this solution truly provides you with a wide range of compliance information. If you're interested in learning more, a survey popped up on your screen just a slide ago. You may have to exit full screen mode to see it. If you would like to receive a complimentary demonstration of the Navigator Suite, simply answer yes, and I will send your contact information to our team of experts for a deeper conversation with you about how we can support your compliance strategy. You may be asking, how do these resources fit in with today's topic? PolicySmart's employee handbook templates include critical compliance information regarding employee investigations, including things like reporting an issue, anti-retaliation policies, discrimination, harassment, and abusive conduct complaint procedures, and Littler attorneys have annotated these documents to include additional information on best practices and tips, lists of things you should remember, helping you have a comprehensive employee investigation guideline. So if this sounds like a support tool that would benefit your organization, simply submit yes to the poll. In addition to a demonstration of our solutions, you may be eligible to receive a free trial of our products, so you can see precisely how much time and money they can save you. If you're not sure at this time, I'll ask once more before we conclude the presentation, or you can request more information via the link on screen in the resources panel or in the Q&A box. Now I have the pleasure of announcing today's webinar presenter, Noah Garber. Noah is a shareholder in Littler's San Francisco office with a focus on labor and employment law, especially including compliance investigations, risk management, litigation, and negotiations. Noah is an expert in today's topic. Noah, thank you so much for presenting today. I'll pass it over to you.
Thanks, Stephanie, and thank you to everyone who's joining us today. As Stephanie mentioned, my name is Noah. I'm a shareholder at Littler. You'll see a QR code on the screen right now. If you want to point your smartphone towards that with your camera, it'll take you directly to my LinkedIn. If you'd like to connect, you can always ask follow-up questions that way. Always happy to connect with folks who are in the HR, LR, investigation space. So a little bit about me. Just my background. I worked at the National Labor Relations Board for about 11 years, where I investigated and prosecuted cases I worked at Kaiser Permanente for about 4 years, and now I've been at Littler for close to 2 years. All told, I've done more than 1,000 workplace investigations. Pretty much everything from a couple people on the janitorial staff aren't getting along, all the way to C-suite misconduct. My practice areas, as Stephanie mentioned, are traditional labor law, mainly the unionized setting, and workplace investigations, and doing trainings like this on workplace investigations. So am I telling you all this because I think I'm so great? Well, that's only partly true. It's really because what I want you to know is I've been in your shoes. I've done the investigations. I've done that work, and so when I'm giving you some tips today, don't think that I'm coming down from my castle in the clouds. I've been where you've been. I've been in those uncomfortable meetings. I've sat with the tough complainants. So today we're going to talk about some tools to hopefully get through those harder and more challenging investigations. So let's look at our roadmap. Today's webinar is supposed to be a continuation of our previous one on investigations. So I'm going to go through kind of the nuts and bolts a little bit more quickly. If you have questions, feel free to put in the chat, and I will try to respond to those. So we're going to start off and talk about why we conduct investigations and the investigation, developing an investigative plan. We'll talk about witness interview and information gathering techniques, what our evidentiary standard is when we conduct investigations, report and documentation strategies, and how we conclude the investigation. So all that's going to be kind of a refresher for if you attended the last session, hopefully some new tidbits here and there. But then we'll get into kind of the meat and the potatoes of our session today. We'll talk about what I'm calling speed bumps, some issues that you might encounter during your investigations, common mistakes that may arise we can hopefully try to avoid. We'll talk about the NLRA, the National Labor Relations Act, and before you roll your eyes, even if you don't have a unionized work setting, those rules still apply to you. Social media concerns, and what to do if we have cross complaints. So starting off, why do we conduct workplace investigations? It's important to remember that investigations promote a safe work environment. And we care about that because, fundamentally, employees have a right to feel safe at work, and a workplace investigation ensures that right. We also want to limit a potential snowball effect. And what I mean by that is we want to know if there's an issue now when there's just one complainant, as opposed to an issue a year from now when we have a class of complainants. So we can kind of nip it in the bud before, if there is something bad going on, before it continues to happen even more. We also want to control the situation. What do I mean by that? We want to handle investigations internally where we control the investigation, as opposed to the investigation going to a third party like a government agency where we have no control over it, or if employees are so fed up, they go to a union to advocate for them. We want to avoid all those. We want to handle the investigations, promptly and do a good job of it so that no one feels the need to go to a third party. Also, we want to prevent reputational harm. You want to be the employer of choice. It's no secret that folks today have no shortage of choices when it comes to where they want to work. If it comes down to, you and another employer, and let's say they do their prospective applicant does their research, and there's something about your company online about how they sweep things under the rug, or they don't care about their employees or anything along those lines, they probably go to the other option. We don't want that to happen. We want to maintain your reputation as the employer of choice. So first thing we want to do when we get an investigation is we want to develop our plan. We want to identify the actors in the chain of command, who works with who and who reports to who. We also want to do a little research and know if there's a history with the individuals involved. That includes, has this issue come up before? Has a person who's accused of committing misconduct, have they been accused in the past? Also, was this previously investigated? Sometimes complainants want a second bite of the apple, and we're never going to do an investigation all over again. So we want to know if this was already looked into. We also want to make every effort to contact our complainant to schedule an interview within 72 hours. That doesn't mean the interview has to happen within 72 hours, but we want to contact them within 72 hours of them making their complaint. That's not a hard and fast rule. That's just kind of the rule that I go by. And the reason is that the longer these things sit out, one, maybe the complainant goes to a third party like we're trying to avoid, and two, the longer it sits, the more they feel that nothing's being done about it. Once we've done that, we want to identify all the issues raised in the complaint. That includes the ones that you see, but maybe were not raised by the complainant. And so what I mean by that is, let's say the complainant raises, retaliation, and within their complaint, they also mention that they complained to their director a year ago and nothing happened. So, okay, we're going to look at retaliation. That's what they're complaining about. But if they just mention in passing this issue with their director, well, is their director trying to hide whatever misconduct might have happened? Is their director just asleep on the job? That's something we want to look into also, because again, we want to limit that snowball effect, right? So we want to know what's going on with all the potential issues. After we've done that, we want to interview the complainant. And I always say move past the legalese. Not everyone, a lot of complainants will raise issues including hostile work environment and discrimination. That's all well and good, but I don't really care about those terms. Those terms are legal conclusions. We want to move past that and figure out what's going on. So, okay, you're telling me that you're experiencing a hostile work environment. Okay, so let's put that term to the side. What are the actual issues going on that's brought you to that conclusion? So we want to know what's really going on, not what the term of art that's being used. We also want to ensure that we're covering all the allegations with the complainant and getting all their documentary evidence. So if they mention a document, make sure to get a copy of it. We're going to contact the accused for a confidential interview and get all of their evidence also. If there's other witnesses, we want to meet with them for an interview. Sometimes we'll flip-flop those. So if our complainant says that their manager did X, Y, and Z in a meeting, and there's all these other witnesses, we want to interview those other witnesses first before we go to the respondent employee to get their side. We'll do follow-up interviews only if needed. We don't like to get into this sense of like ping pong, going back and forth with people. It creates a belief that they don't feel that you believe them. It also creates a sense that maybe there's something else going on. So I try to avoid that if possible. Sometimes you can't avoid it, and sometimes you need a response to a newer allegation. But if possible, we're going to try to avoid those. After that, we're going to draft our report that will outline all of our findings. So that's kind of our plan in general. One of the biggest issues, though, comes when we're interviewing witnesses. So when we start off with a witness, I don't love the term admonition, but I'm just using it here. We're going to talk to them about our neutrality, the investigative process, and confidentiality. So when it comes to neutrality, I always tell witnesses right up front that, look, I'm completely neutral. I'm not here to say that you or anyone else has done anything right or wrong. If I ask you if you said or did something or someone else said or did something, one, I'm not saying that it happened, and two, even if it did happen, I'm not necessarily saying that there's anything wrong with that. I pass no judgments on anything you tell me. I also kind of warn them that I ask a lot of follow-up questions and not to be concerned about that. It doesn't mean that I don't believe them. It's more that they lived through it. I didn't. Something might seem obvious to them, and it won't be as obvious to me. The whole idea is you're trying to build rapport with them. If your witness doesn't trust you, they're simply not going to talk to you. So you need to build that safe space for them to feel comfortable talking to you. I also talk to them about confidentiality. And so I always tell them, look, this investigation is completely confidential on my end. I'll never discuss what you tell me with anyone else. So if you work with someone or report to somebody, or they report to you and they ask me, hey, what did so-and-so say during their interview? One, I'll never confirm that we've met. And two, I'll have a conversation about not asking about confidential investigations. The idea is that, again, we need to create this safe space for them to feel comfortable talking. Now, I also tell them there's a limit on that, too, in that when I'm done with my investigation, I'm going to draft a report, and my report will only go to whoever it's going to. Usually it's HR or the legal team, but other than that, no one will see a copy of my report. Again, the idea is just building a safe space for people to feel comfortable talking to. I always tell people when they're interviewing witnesses to be Ted Lasso. And full disclosure, I've only seen one episode of Ted Lasso ever. I thought it was kind of a ripoff of that 1990s movie Major League, but that's not here nor there. My wife loves the show. She's watching an episode, and I walk through the room, and I hear Ted Lasso talking to his team, and he says, "Be curious, but not judgmental." If you take nothing else from today's training when we're talking about interviewing witnesses, remember this: we are always curious, but not judgmental. It's through the tone of our questioning and how we talk to people. We can ask questions. We can do it in a non-judgmental fashion. So we say, okay, tell me why you did this, as opposed to, why did you do that? Why would you think that's okay? Walk me through what brought you to doing that. See the difference in the inflection of my voice? Same question, we're getting to the same result. One's non-judgmental, one is. When we're actually interviewing employees, we want to use what we call the funnel technique. And so we're going to start out like pretty wide and get more narrow with our questions as we go on. So we'll start off with easy questions on background. How long have you worked there? Tell me about your job duties. That sounds very difficult. I'm sure you do a lot every day. Just kind of, again, we're building rapport. Then we're going to get on to some more open-ended questions. Tell me about this meeting on this day. Walk me through what happened to the best you can remember. Then we'll get into more directed questions if we need be. Did you say X? Did so-and-so tell you Y? That sort of thing. Only if need be are we going to get into these cross-exam style questions. Again, we want to keep building rapport. We want people to feel comfortable talking to us, but there's sometimes when we just need an answer to a question that's not being provided. And so we might have to ask them, something along the lines of, you told me X before, and now you're telling me Y. These conflict, so help me understand that. We want to get to the bottom of it, but again, we're still not being judgmental. As I mentioned before, if documents are mentioned, let's get copies of those. It's also important to be an active and engaged listener. However you take notes in your interview is up to you. I type because I'm a geriatric millennial, so I learned how to type fast from AOL Instant Messenger. So I can type while looking at somebody without looking at the keyboard. That's what works for me. Some people handwrite their notes. That's totally fine too. Whatever your process of taking notes is fine. The idea is that you still have to be able to look at your witness and engage with them. We're not stenographers. You have to build that rapport with them. And part of the reason why we want to be looking at our witnesses is because at some point, we're probably going to have to assess credibility. And so this is not an exhaustive list, but these are some of the things that we want to take into account when we're judging the credibility of our witnesses. The inherent plausibility, does their story even make sense? Does a witness have a motive to lie? Do they have anything to gain from what they're telling us? Is someone's story corroborated where another person's story is not? Does one witness have an ability to recall facts and events better than someone else? This is one that some people talk about, a history of honesty or dishonesty. I always say be careful with that. One, it implies that the witness has been involved, with investigations in the past. And two, just because you're honest or dishonest in a previous investigation doesn't mean that you're going to be honest or dishonest in this matter. Inconsistent statements, are they telling you one thing 1 minute and then later on in your interview, are they contradicting it or telling you something that just doesn't follow it from that? The manner of the testimony, this is a big one. This is why we want to be able to look at our witnesses. Are they hesitating? Are they, shifting in their chair? Are they looking away from you? Are they, giving you indirect answers or trying to jump around, jump and not answer your questions? Things like that. Demeanor is something that some people will gauge. I don't love to do that, and I always say use with caution. We have to consider cultural differences. In some cultures, it's disrespectful to look at elders in the eye. In some cultures, they may have a sort of history with, law enforcement. Not that you are law enforcement when you're conducting this investigation, but you could be perceived as that. So, we want to kind of keep an eye on things like that and be mindful of potential cultural differences. So we're doing our investigation, but we have to have a standard to judge it on. And the standard that I always recommend is a preponderance of the evidence. This is not beyond a reasonable doubt. This is a much lower standard. We also call it the more likely than not test. Essentially, it means 50% plus one. So if you were to weigh all the evidence, is something more likely than not to have occurred? And the example I always give is this. If I have a bucket of stones in each hand, and you place a pebble in the bucket in my right hand, just making that bucket just a little bit more heavier, that's a preponderance of the evidence. That's all it takes. It's just 50% plus one. So turning to our report and documentation strategies, you can do the best investigation in the world, but if you can't do a good job documenting it or communicating it to your leaders or whoever needs to read it, the investigation doesn't really mean much, right? So this is really important. We need to know our audience when we're drafting our investigative report. I always say don't use acronyms because you don't know who's going to be reading the report later on. When I worked at Kaiser, we had an app just for acronyms because there were so many acronyms, and it used to drive me crazy. But again, you just don't know who's going to be reading it, whether they're going to be able to understand your abbreviations. If you want to define your abbreviations, that's fine, but don't just launch into them. Also, plain English is fine. I feel super smart when I use like fancy Latin terms and things like that. But who cares about that? Absolutely nobody. So again, plain English is just fine. We want to make sure we address all the allegations raised, and we need to make a record of our reasoning and the steps taken so that we can show that we connected, the best possible evidence to our findings. This seems obvious, but it sometimes slips through the cracks. We need to also reach a factual finding for each issue. We can't just globally say the allegations are unsubstantiated. You could say that, but then you have to have your subheadings or some sort of bullet points or something addressing each individual allegation also. Again, this is going to sound obvious, but it's hard sometimes. We have to remain neutral and objective. That can be tough sometimes in our reports, especially when maybe you don't love the person you're dealing with, or they were not so nice to you in the interview. So again, remain professional in the language that you use, and neutral and objective. So now your investigation is done, but it's important to remember, just because the investigation is done, your work is not done. You then have to close out with the complainant and the respondent. And the reason being is if you don't tell them, what the findings are, and you don't have to go into fine detail about it, you can just tell them, it was substantiated or unsubstantiated. But if you don't tell them what happened, especially with the complainant, they think that nothing happened. And then if they think that nothing happens, maybe they're going to a third party to complain, which again, we're trying to avoid. We also want to make sure that when the investigation is done, we're handing off to the appropriate party for any remedial action. Maybe there's discipline that needs to ensue, maybe not, but what if there's alternatives? Like what if, there's training or mediation or EAP, things like that. We want to make sure we're moving this to our HR partners or LR partners or whoever so that we can remedy the situation. And if there's no remedy that's needed, maybe we can, employ some of these other tools to prevent, whatever's going on from happening in the future. File maintenance is like a really big deal. You have to remember that you may not be the only person who looks at your investigative file. There could be litigation further on down the road. You may leave your employer and someone else may need to find this investigation later on. You should be saving all your documents in one area, using like normal naming conventions that people can understand, like investigative report, so-and-so name, something like that, just so someone later on can identify, where the report is and things. Apologize for that. So that's kind of our recap of the nuts and bolts. Turning more towards some potential speed bumps that you might face when you're doing investigation. What do you do when your complainant is anonymous? So you might get this complaint that says, my director is always, cursing us out. He's super mean to us. He never approves our sick leave, and he makes us work like undocumented overtime. I'm just making all this up, but it's anonymous. So what do you do at that point? We want to then look at the org chart, find out who the respondent is, who this director is. We then want to chart out who reports to him, maybe directly and through a dotted line. From that, we're going to interview some folks. But because we don't know who to interview, what we want to do is we want to look at a representative complement of the folks that report to this respondent employee. And by that, I mean, let's say 20 people report to this director. You don't have time to interview 20 people. Like, that's not reasonable. So what we want to do then is we want to choose, maybe 4 to 6 employees. We want to get equal number if possible of men and women. And we'll look at the names of the folks there, try to, you can't make judgments solely based on someone's last name, but we'll look at the last name, see if we can, see if they're coming from different ethnicities or cultural backgrounds, and we'll then interview, those people. The idea is that we just want to get diversity of opinion, diversity of thought when we're looking into this anonymous complaint. When we're actually meeting with those folks, then we'll kind of ask them pretty open-ended questions related to the whatever the allegations are that the complainant has raised. Have you ever experienced this director talking down to you or using inappropriate language? Things like that. Then, based on what they tell you, then we'll move on and say, well, have you ever heard of this happening to anyone else? Has anyone raised this kind of complaint to you in the past? The idea is we just want to try to figure out what's going on, if possible. Even though the complainant doesn't feel comfortable coming forward, we still want to figure out, is there a bad actor going on? Or is there a bad actor, and what is going on? What do you do when your complainant is unresponsive? So I'm your complainant, I filed my hotline complaint, and then you're the investigator, you're reaching out to me, and I'm just ghosting you. I'm just refusing to, it's not even I'm refusing to comply or cooperate with the investigation. I'm just not even responding. We never ignore complaints. Again, there could be a bad actor. We want to know. So what we want to do is we'll reach out a few times to the complainant. I like to do it in writing so that there's a record of it. I usually do it 2 times. The second time gives them a firm deadline, saying, please contact me by X date. And then I throw in a line that, please note that I'm committed to investigating all the concerns you raised on whatever date or via whatever form. If you don't contact me by this date, I'm still going to investigate all the concerns you've raised, but I'll do so without the benefit of your input. The idea being that we're still going to investigate it. We still want to know if there's an issue, and we don't want the complainant to think that nothing was going on, even if they're not cooperative. And so we want to make a record of that also. Then at that point, we're then kind of going back to what we're doing with if your complainant is anonymous, we're going to look at a representative complement to interview folks. What about when your complainant changes their mind? And this happens frequently. So your complainant comes forward, they raise an issue with their manager, and then they say, oh, I don't want to blow this out of proportion. This is no big deal. I don't really want to go through this. Like, I just don't want to be involved. So, case closed, right? Unfortunately, not so fast. You got to remember that our complainants could be intimidated by the process. They could be nervous about the process. They could fear retaliation, whether there's good reason to fear that or not. Maybe they could be coerced by somebody. We don't know. So, the idea is that they've come forward with this complaint. We are now on notice of it. We still have to investigate it. Hopefully your handbook has something in it about, compelling cooperation. If it doesn't, we're going to employ what we just talked about, giving them the deadline to cooperate. And if they don't, we're still going to investigate it. We'll do it without the benefit of their input, but we'll still investigate, and then we go back to our representative complement. The idea with all these is that maybe there's a bad actor out there. Like, we don't know what we don't know, and we still have to investigate to figure things out. This one's one of my favorites, and by favorites I mean least favorite to deal with. What do you do when your complainant, is throwing spaghetti against the wall and hoping that something sticks? They're just telling you, maybe it's in their hotline complaint or their interview. They're just starting to list, give you a laundry list of things that have been going on for the past 10 years. There's really no way that you could, competently take notes about something like that without preparation. So what I like to do is I usually will stop the interview, explain to them we're still going to interview, or we're still going to, investigate every concern you want to raise, but we have to do it in a way that's, a little bit smarter, and so that we don't. I always, tell them we want to do it in a way so that we don't miss any of the concerns you want to raise. So I asked them to provide me a list. I asked for it to be in chronological order. And what I would need from them is a list of all the concerns they want to talk about, with just like, a sentence or two description of what's going on. I don't need it to be, a full paragraph, but it could be something like retaliation, and then summer 2022, director told me that if I, they were going to let me go if I didn't do X, Y, and Z. Okay, that's fine. We'll check that off. That's one we're going to look into. We want them to do that for everything that they want to discuss. One, we don't want to miss any of the allegations that they want to talk about. But two, we also need like a coherent way of doing it. If they're just going to spitball at you, something's going to get lost. And later on, they may accuse you of not investigating everything. You can always come back and rely on this list and say, hey, I asked you for everything. You provided me that list. We went through all of that list. This can be a tough one too. I always tell investigators, don't miss the forest for the trees. And by that, I mean, don't get caught up in side stories. Your interviews will sometimes be therapeutic for your complainants, and that's okay. I think to it, not that you should be giving, therapeutic advice, but I think to a certain extent, the investigative interviews provide our complainants with an outlet just to get everything off their chest. I'm not saying you have to listen to them, for days on end, but sometimes it's helpful to let them feel heard. You never want someone to say that they were not heard, because then they're calling into question, how good your investigation was. With that said, if they're going to drone on about everything, under the sun, that their manager, they said hi to their manager, and their manager only said hi to them, 75% of the time, is that misconduct? No. You still want your complainant to feel heard? Yes, but we don't need to get lost in those types of like, ticky-tacky things within the investigation. We still want to focus on what really is, are the issues at hand. So again, we want to focus on the big picture, the allegations, make someone feel heard, listen to them, but we don't need to like dive into, every little aspect that they feel slighted by. This is one of my like pet peeves. Sometimes you will be working on an investigation. I find that this happens more often when your complainant kind of can, smell the direction of the wind, and they know that their complaint is going to be unsubstantiated, and so then they'll start to raise new claims, or you'll tell them like, hey, we conducted this investigation, and it's unsubstantiated, and they say, okay, well, you didn't look into this. Maybe they didn't tell you about it either. But the idea is they're raising new claims after you've already interviewed them. That's annoying. That's okay though too. We still want to investigate it. We're on notice of the complaint, so we still need to look into it. When I have a complainant who's doing this, then we go back to our spaghetti against the wall tactics, and then I ask them for their chronological list. Say, okay, you didn't raise this before. That's okay. I'm still committed to investigating all the concerns you want to raise, but just so that I know I'm covering everything, I need you to provide me with a chronological list of everything you want to investigate, or every concern you want to raise. And again, you ask them for that list to be in chronological order. You ask it for like a sentence or two about what's going on, that, my director didn't, give me a promotion, and he promoted this other person because of their ethnicity. Doesn't have to be super specific, just kind of an idea so you can help prepare for your interview, and so you can get a list from them so that they can't later on claim that you didn't investigate all the concerns they wanted to raise. There's no shortage of common mistakes, and these are mistakes that we are all guilty of at some point. Anyone who tells you that they've never made any of these mistakes in their workplace investigations, I tell you that they have not done enough investigations. So delay is a really big one. We've touched on this a little bit, but it's important to remember that you can't. It's not reasonable to expect you to drop everything for every investigation the moment it comes in. That's why we want to contact our complainants within a reasonable amount of time. I always suggest 72 hours to just schedule the interview, or just to make contact with them saying, hey, I'm Noah, I'm going to be investigating your concerns. I'll be reaching out to you soon to start the investigation. It's important to remember, if our complainants think that nothing is happening, then to them, nothing is happening. They think no investigation will actually happen. That's what prompts them to go to a third party. Maybe they're going to a government agency and asking the government to investigate it. Maybe they're complaining to a union and they're going to start organizing. All things that we just want to avoid. Providing updates when possible. You don't need to, and you shouldn't, provide updates on the evidence that you've gathered. The idea is just to keep our complainants aware that you're still working on it. Sometimes investigations go on for months. Sometimes you need to talk to somebody and that person is on protected leave, and you're not going to be able to interview them until they come back. That's just the reality of workplace investigations, right? So we just need to make our complainants aware of what's going on. That's all. Just give them updates. Excuse me. Another issue that comes up is that some people think that all complaints have to go through the hotline, or that there needs to be a formal complaint. Both are super false. Knowledge is knowledge. If you have knowledge, and I mean your employer, has knowledge of a complaint, it needs to be investigated. Just period, hard stop. It doesn't have to go through a hotline. It doesn't have to go through any specific mechanism. It doesn't have to be written. It could be a text message. It could be a statement in passing to a supervisor. If somebody has knowledge of a complaint, it should be forwarded to HR or your ER folks, whoever does this type of work. We need to forward it to them so it can be triaged and then investigated in a timely manner. Let's say you're doing investigations under privilege. If so, let's keep it privileged. Don't talk about the investigation with friends or coworkers or in the lunchroom or anything like that. I know it's super common. We all talk about our work, and we all commiserate about our work with our coworkers, and that can be cathartic. But if it's privileged, it has to stay privileged. Just don't talk about it with anyone else. That includes not sending the report to folks who are outside of the privilege circle, and marking your report ACP, attorney-client privileged, as well. Like I said, there's no shortage of potential issues that come up when we do these investigations. This is one of the biggest ones. Don't become part of the case. And so what do I mean by that? Depending on how long you've done this, at some point, you are going to come across a witness, whether they're a complainant or a respondent or a third party, whoever, who you just will not like. It's just a fact of life. You are going to come across somebody who is just not a nice person. They're rude to you, or they're, for whatever reason, they're just a jerk, for lack of a better term. You have to rise above it. I'm not saying you have to take abuse, because if someone is being, verbally abusive to you, you just end the interview. That's not a big deal, and we'll talk about that in a minute. But you just can't show bias. If someone starts cursing at you, you can't curse at them back. If someone's accusing you of bias, you say, I'm sorry you feel that way, but I'm committed to investigating this in, a neutral manner. If someone is really being abusive towards you, if there's any physical violence, obviously you want to make sure you're safe and call security or the police as soon as possible. But if they're just being verbally abusive towards you, you can end the interview and say, I need to investigate these. It seems like we're getting a little heated. Let's just take a timeout, and I'll contact you at a later date to continue the investigation. Again, you don't have to like the person. You will dislike somebody at some point, but we still have to be committed to the investigation. And it's important to remember, you don't want later on that your complainant or respondent to tell you, oh yeah, well your findings don't mean anything because the investigator, mouthed off to me, or the investigator told me to F off, things like that. We want to maintain anonymity whenever possible. And that's not limited to just when someone asks to remain anonymous or if our complainant is anonymous. We never out our witnesses, period, hard stop. When we start outing witnesses, saying that like Joe told me this, what's your response to it? Our witnesses stop coming forward. So we need to maintain their anonymity as much as possible. Sometimes that can be tough, but one of the things we'll do is, the allegation is that, manager Dave told employee Noah, I'm going to fire you if you don't get in line. When you're talking with Dave, you're not going to say, did you tell Noah X, Y, and Z? Say, did you ever tell somebody this? Or did you ever tell anybody anything along those lines? So we can still get the information. We can do it without outing the person. What if our complaints are, they're unfounded, or that we find them unsubstantiated or even inconclusive? What if there are other issues though going on? So what if the allegation, just for example, is managers are abusive to employees, and employees are stressed because they're so short-staffed on the hospital floor. I'm just making this up. Well, maybe the actual allegations about verbal abuse and the treatment of the employees isn't accurate. But what if short staffing is? That's not necessarily something that you're is proper for an investigation, but it's something we want to flag because it's still something that we can be remedied. If we see something that's not quite right, we still want to flag it for our eventual reader or decision maker of our reports so that they can remedy these other issues. So what if there's short staffing? What if there's cultural issues between folks involved? We could employ EAP, we could employ mediation, things like that. Okay, so everyone's favorite topic is dealing with unions. Said nobody ever. This is meant to be a crash course on the NLRA, the National Labor Relations Act. And yes, this applies to your non-union employees. So if you think you're exempt from this because none of your folks are unionized, you should still pay attention. So again, this is a crash course. So Section 7 of the NLRA, that protects employees' ability to discuss wages, hours, working conditions, and band together for mutual aid, benefit, and protection. So Section 7 gives employees those rights. Section 8A1 of the NLRA prevents an employer from interfering, restraining, or coercing employees from engaging in those Section 7 rights. So Section 7 are the rights. Section 8A1 makes it unlawful to interfere with those rights. All of this, the NLRA, with one very small exception that doesn't apply here, only applies to what we call statutory employees and not statutory supervisors. When this comes up, usually someone says, oh, well, this person's job title is supervisor. Job title means almost nothing. What it comes down to is their actual duties. And so by that, I mean, do they use independent judgment to do things like hire, fire, transfer, layoff, responsibly delegate, task to employees, grant overtime, things like that. If they do any of those tasks, they are statutory supervisor. The NLRA does not apply to them. If they don't do any of those things, they are statutory employee. The NLRA does apply to them. They can engage in the Section 7 rights that we've discussed, and it's unlawful to interfere with them under Section 8A1. So traditionally, when you're conducting a workplace investigation in a union setting, if an employee has a reasonable belief that discipline could ensue from their investigatory meeting, they have the right to what's called a Weingarten representative. That is a union rep that can advocate for them during the meeting. The meeting can't be adversarial. They can't interfere with the meeting, but they do have a right to that rep. That's traditionally how the law has been. Now, the NLRB, the National Labor Relations Board, the agency that enforces these laws, they are making a push to apply that to the non-union setting. That is not the law right now, but they have raised that in some cases. So just something to keep an eye on in the future, that if that changes, if you have a statutory employee who you're investigating, and that employee has a reasonable belief that discipline could ensue from whatever you're investigating, they would have a right to have, another employee representative present during the investigation. So before we get to social media concerns, the reason why we go through all that stuff about the NLRA is that we want to be careful when we're conducting investigations. This is going to come up in our social media stuff. If the conduct that's complained of is protected, then we don't investigate it, because the investigation, the interview, could essentially be what we call an unlawful interrogation, meaning that it's a Section 8A1 violation because you are interfering or coercing employees not to engage in Section 7 rights. So just as an example, one employee posts on social media that, they don't think it's fair that they only make, X per hour, they need more money, and their employer's, a cheapskate. And then another employee comments on it and say, yeah, I agree with you. Okay. Well, we have multiple employees talking about wages, and they're also banding together for mutual benefit because they're talking about how they need more money. So even though you're unhappy with that post and they call you a cheapskate, that's protected under Section 7. If we were to investigate that, we could potentially be looking at an unlawful interrogation because we're interfering with employees engaged in protected Section 7 rights. So now, turning a little bit more towards social media concerns. What happens when your misconduct actually occurs on social media? We want to triage immediately, respond ASAP, because the information's out in the ether, so we need to do something about it, right? We're not going to litigate in public. We're not going to, start to do our interview, in the chat section or in DMs or anything like that. But we want to just respond immediately saying, we're sorry that this happened. Thank you for raising these concerns. We're sending you a DM or whatever direct message to connect with you further. From there, we schedule our confidential interview. The idea is we just want people to know, one, we need to investigate, but two, our complainant has put this out in the internet, whether it's Facebook or Twitter or wherever. Instagram's a big one now, obviously, where people complain. Not only do we need to investigate, and do we want the complainant to know that we're going to investigate, but since they've raised this out into the public, we want to show to the public, hey, we take this seriously. We're going to look into it. As we mentioned, we want to keep an eye out for what we call protected concerted activity, PCA, the Section 7 rights. So if folks are engaging in PCA online, we may not like it. You may find it embarrassing. It's lawful. We don't want to investigate it. If there is something posted on social media that we don't, that raises a concern or it's misconduct, we want to keep an eye on the post, take a screenshot of it for evidence so we have that. We also want to know, are other folks commenting on it? Like, well, let's say I post on Facebook that my manager, mistreats me and is always a jerk to me. He's using foul language. Okay, well, to contact me because I've made that initial concern. But what if other people start commenting saying like, oh yeah, my manager does the same thing to me and he did this to me on this date or whatever they're saying. Well, now we have another complaint involving the same manager. We want to then contact that person also. So we just want to keep an eye on the social media message just to see if anything else spawns from it. This is a tough one. What do we do when we have cross complaints? Sometimes they come up at the same time. My manager accuses me of misconduct and I accuse my manager of misconduct. Sometimes they may come like tit for tat. So what do? Well, you start where it makes sense. And that doesn't always mean that you start with whoever came in first. Maybe you start with the witness that has the most to talk, has the most allegations to cover. Again, because we're keeping it all confidential, none of our witnesses will know or should know who you started with. So they won't know, if you started with the director first, the manager, or the rank and file employee when you have these cross complaints. I do think it's important, though, to be upfront with your complainant and say, just so you know, there are these other concerns that we're going to talk about, but we're not going to talk about them today. And the reason why we're not going to talk about them today, this is just what I'm telling you now, what you tell them, is that, again, we're building rapport with them. If we're telling the employee, tell us everything that happened, I'm going to investigate them. Okay, I'm sorry that you went through that. Thank you for telling me all that. And then, oh, by the way, did you do this to your manager? Did you do this to so-and-so? Your rapport is gone. Maybe they're not going to tell you anything further. So we want to have separate interviews. I know that extends the process, but I always prefer to do it that way. That way you're having the interview with them about the concerns they've raised. They feel good about bringing everything there, raising everything in that time period. And then after that, you can circle back with them and say, okay, now I need your response to these allegations. And then go through those. So separate interviews for separate issues. I see we're starting to run a little short on time, but this is what some people call it our Candyland map. This kind of reminds me of that movie, A Beautiful Mind, with that math professor where, he sees things that no one else sees that are flashing, and it's a little crazy. It's a little bit hard to take in on the screen, but it will be part of the package of documents that you can download as a result or from this training. This is just kind of a step-by-step, check the box sort of thing for your investigations protocol. It's not going to work for every single complaint that you ever get, but the idea is it's just best practices to employ whenever something comes up. So maybe they don't apply in every instance, but again, you can just, whenever you have an investigation, you can take a quick look at it, make sure you're doing everything you need to do, and you haven't skipped any steps. And so with that, I can turn it back over to Stephanie, and I'll take a quick look at the chat, see if I can answer any questions too.
Thank you, Noah. Holy cow, there are so many different risks associated with employee investigations, and it is such a complex topic. So thank you for providing us with the in-depth look today at the risks associated. For anyone who has questions and has not yet submitted it into the Q&A box, I invite you to do so now. And Noah, while you take a moment to review the questions that came in from today's presentation, I would like to offer another opportunity to today's registrants for a demonstration of the Navigator Suite. With all of the possible pitfalls of employee investigations and employee and employment law in general, it's critical you don't leave your compliance strategy up to chance. Our suite of solutions is designed to support employers like you while saving your organization time and money. In addition to important topics like employee overtime, independent contractor classification, leave, and onboarding documents, our PolicySmart and Reference Center solutions support investigations specifically. PolicySmart's employee handbook templates include critical compliance information regarding employee investigations, including reporting issues, anti-retaliation policies, discrimination, harassment, and abusive conduct complaint procedures, just to name a few examples. The content is annotated by Littler attorneys to include commentary for your HR and legal teams with necessary steps to take during an investigation. The Reference Center includes in-depth state guides, which would have local and state information should the rules vary from the national requirements. So if you're interested in learning more about these tools, I'll leave the poll open until the end of the presentation today. But Noah, while I was giving my spiel, did you find any questions that you'd like to respond to?
Yeah, just real quick as I'm running through these. One is about whether it's okay to not reach a conclusion in your investigation, meaning like it's inconclusive. We really try to avoid that. Usually our terms are, substantiated, unsubstantiated. From time to time, it will be inconclusive, meaning that there's just insufficient evidence to conclude with a reasonable degree of certainty whether the conduct happened. Nobody likes that outcome. The complainant feels like you didn't believe them. The respondent feels like you didn't believe them. Your leadership team is like, okay, well now what the heck do we do with this finding? We try to avoid that if possible. We want to look at all the evidence and we're going to look at our credibility issues too. But sometimes it just can't be avoided, and that's just a fact of life. So we try to avoid that, but sometimes it really can't be avoided. Um, Somebody says, I find it difficult to take notes during an investigation. What are some good tips? It's okay to tell your witness to pause for a second. I do that sometimes too. I type super quick, but sometimes they talk faster than I can type, and I'll just say, okay, hold on 1 second, I'm just catching up with you. Give me 30 seconds. That's all. And so you just do that. It's okay to tell them to pause for a minute while you catch up with them. Somebody asked about Johnny's Poultry in a non-union work environment. Johnny's Poultry is an NLRB case that really gets misapplied. Johnny's Poultry are assurances that you only need to give to an employee, again, a statutory employee, not a supervisor, when you're prepping for an unfair labor practice trial, like a ULP trial or an arbitration, something like that. You don't need to give Johnny's Poultry assurances as part of a workplace investigation. And the assurances are essentially like, this is voluntary. You don't have to answer any of these questions. Nothing bad will happen to you as a result of cooperating with this. You should tell them nothing bad will happen as a result of cooperating with the investigation. But if hopefully your handbook says this, but they do have to cooperate with the investigation. Let's see. There's one about if there's a corporate-wide investigation, should the board notify employees? That's kind of a case-by-case situation. I don't usually love doing that, only because there are people who don't know about the investigation and now they do, and we don't want to sully the waters of our potential witnesses. But it also could be a big enough issue that's in the news that you want your workforce to know that you're taking it seriously. So that's really a case-by-case situation. If an employee is disciplined, do they receive a copy of the report? No, I never give a copy of the report. The only time you give up a copy of the report is if there's litigation, and then as part of the discovery process they request a copy of it. And even then there's some limitations. But no, we don't give up a copy of a report. The only time that it's limited besides litigation is if you're in the union setting. The union can make an information request asking for, your notes or your report, in which case you might have to give it. But we're also going to redact like names and stuff like that, so that we're not outing employees. You'll have to bargain with the union over an accommodation like that. Also, there's a lot of really good questions, and so maybe I can look through these and respond later, just because there's a ton to take in here. This is a good one. What do you incorporate in your notes as far as credibility? And I see we're running short on time. So what I like to do is I type in normal font, and then if there's something about credibility, I quickly hit, Control U and Control B, meaning underline and bold, so I know that that's a flag to myself when I'm looking at these notes later on. And I'll just put in like a word or two about what's going on, like long pause, looking away, not answering directly, things like that. So they're notes that I can then look back on. I can look back at later on and remind me, okay, yeah, this person was less than credible during their interview. I will look at these questions though, and see if I can triage some of them. I see we're short on time. Again, I'm just going to throw my QR code up again. Feel free to connect with me if you I hope you found this helpful. If you'd like a similar training at your workplace, I do that as well. Please feel free to reach out to me.
Amazing. Thank you so much again, Noah. We really appreciate you presenting today, and thank you to everyone in attendance. We appreciate you taking time out of your busy work schedules. I hope you all have a wonderful day.
Thank you.